Disputes in the mining sector are rising and getting more expensive. Research commissioned by Burford Capital shows nearly two-thirds of mining companies have spent more than $5 million on litigation or arbitration in a single year. Many expect disputes to climb further amid tighter regulation and growing competition for critical minerals. Well, Jeffrey Commission is a director at Burford Capital, focused on international arbitration and investor-state disputes. Jeffrey, thanks very much indeed for talking to us.
Thank you. Very happy to be here.
Well, look, critical minerals have certainly dominated headlines recently, but are we also seeing a rise in mining disputes linked to those projects?
I think we are, and I say that in two respects. We are seeing disputes between mining companies, both majors as well as juniors, against governments in various jurisdictions in which they're operating. And then we're also seeing, and those are what we commonly describe as investor-state disputes, where you have an investor on one side and then a sovereign or government on the other. And then the other kind of dispute is an international commercial arbitration, where you have arbitrations between two companies. Oftentimes, we're seeing in the mining sector between two mining companies. And again, oftentimes that commercial arbitration is a follow-on arbitration as a result of some sort of government action or inaction.
Yeah. Which leads me to my next question. You partly explained it there. For viewers unfamiliar with it, what exactly is third-party funding? I mean, often called litigation or arbitration finance. And how does it work in simple terms, Jeffrey?
So in simple terms, third-party funding, or what I like to term it, arbitration finance, is where a funder pays for the fees and expenses of an international arbitration in exchange for an entitlement in the award proceeds. So, as you rightly mentioned at the outset here, these international arbitrations are increasingly quite expensive. The average spend for many of them is at least $5 million. And not only are they expensive, but the duration can, at least in recent years, become quite long. So you're going through you're spending $5 million in an original arbitration, and then it could take 3 years, it could take 5 years. You may face an annulment or a set-aside application, even if you win, and then you have the matter of collection. So because of that, these concerns about cost and duration, it's something whereby funders, I think, can add real value in providing capital to allow, in the main, junior mining companies to pursue what in many events are cognizable claims.
I'm very interested in the traditional landscape here. Have mining companies historically used arbitration finance, and how widespread is it in the sector today?
It's an interesting question, and it's very difficult to explain or tell the story of litigation funding or arbitration finance without talking about mining companies. Some of the very first funded cases are in the mining sector. Some of the cases I worked on as counsel, prior to joining Burford, I worked as counsel at a leading international law firm. And a number of those cases were for Canadian junior mining companies against Latin American sovereigns. And those cases were funded. And, as it happens, those cases ultimately were successful. And so the story of third-party funding is inextricably linked with the mining sector. And that continues to this day. If you look at the data that's provided by the arbitral institutions that administer these disputes, an increasing proportion relates to the OGM category, as the World Bank classifies it, oil, gas, and mining. And we've seen year-on-year increases both in the data provided by ICSID as well as by the ICC, the International Chamber of Commerce.
You would perhaps get some mining companies watching this thinking, well, what makes a mining dispute financeable? I mean, when you assess a claim, what are the key factors that determine whether Burford Capital will invest, and when do you walk away?
Again, a good question. Typically, when we due diligence a claim, I should say at the outset that we, like many funders, turn down 95% of the claims we see. So we have to be quite selective, obviously, because our capital is non-recourse. We don't control these cases, and if we lose that capital. So when we're looking at projects or cases, arbitrations in the mining sector, we're doing diligence on the counterparty. So the foreign investor, the claimant, what kind of company is it? Have they been successful in other mining projects? How far advanced were they in the exploration process? How far did they get? Did they get to a feasibility stage? Was there a 43101 feasibility study completed? How far did they get in the permitting process? How far did they get in advancing what we see in many cases now, the social license in respect to the local communities in where many of these projects are based? We also look at the party on the other side. Where is this mining project? Does that country have a track record of making payments or settling these cases? So I would say the three things: the counterparty, the respondent, and the stage of development, and how much that foreign investor has invested. Because in a worst case scenario, and a tribunal is not comfortable with awarding significant damages based on a DCF, they will award, in some cases, amounts invested. So how much did that foreign investor invest in the project, and how long were they there?
Yeah. Look, linked to that, I'm wondering what is driving mining companies to turn to this type of funding right now. I mean, is it mainly cost pressures, risk management, or something else?
I think it's a mix. I think historically, I've been now in arbitration finance for about a decade, and if you go back 10 years ago, I would say most of the claimants were borderline impecunious. They were one asset junior mining companies who, and these were predominantly Canadian or Australian companies, who would invest 5 to 10 years in a country, and then at the moment of either production or a significant reserve classification, there would be an expropriation or a government action that was tantamount to an expropriation. And for those companies, it was clear they could not pursue a claim but for fees and expenses funding from a funder, because they didn't have the capital to pursue it on their own. Fast forward 10 years, and we see claims not only from those kinds of thinly capitalized companies, but also from Fortune 100 companies and leading companies where this is just another asset. Increasingly with these larger companies, they may have judgments or awards in the mining sector that they are tired of seeking to enforce around the world. So oftentimes what we can do is we can monetize those, because they are, like anything else, just another asset, and we can purchase those, obviously at a discount to their face value, but it provides that company with immediate access to capital that they can deploy on things, on matters that they know and do well, which is, operating a mine or progressing projects around the world.
Look, as I let you go, Jeffrey, I mean, winning an award is one thing, enforcing it is another, right? I mean, in cross-border mining disputes, what are the real challenges around recovery, and how do you assess enforcement risk from the outset?
It is a very difficult and challenging issue, and I wish I could say it's getting better, but it's not. I would say your average arbitration lasts about 4 or 5 years, at least in the investor state context. And then increasingly, we're seeing oftentimes another 3 to 5 years before you can collect those award proceeds. We are seeing counterparties or respondents in this scenario challenge successful awards in favor of claimants. So you've got another 18 months to 2 years before the local courts or before an annulment or an ad hoc committee. And then either during that period or after, if there was a stay of enforcement, you are then engaging in a coordinated and multi-jurisdictional enforcement campaign where you're trying to bring pressure to bear on this sovereign through various assets. You're trying to pierce the corporate veil of state-owned entities. You're trying to, it's really a multifaceted approach. And it's not, unfortunately, it is, it's capital intensive and it takes time. There are exceptions. There are sovereigns who have settled, and we've seen some recently in Africa. But more often than not, you are in for a long and protracted enforcement campaign.
Well, leave it there. Very insightful indeed, Jeffrey. Thanks very much indeed for talking to us. It's Jeffrey, Commissioner Director at Burford Capital. Jeffrey, thanks for your time.
Thank you very much.